going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy Hump Day. Yeah, halfway through the week. And as someone just said, 2 weeks until Christmas. 2 weeks. 2 weeks. Better start figuring out where you're going to order if you haven't ordered your presents yet. You're getting close to that crunch time where Amazon's going to be like, nope, you're not going to get it. All right. Let's see. What do we got tonight? I've got a bunch of random stuff tonight. A lot of core geniuses tonight. We've got everybody. I think I've got 6 or 7 clips to share tonight. We're going to have a good night. I have the Judge Boyd clip that I tried to play last night. Failed miserably at it. So I have that tonight. And I told you guys I was going to play it tonight. Guess who made their video for tonight and didn't put that clip in? This guy. So I had to recompile it separate to have it separate. So I'm going to play it at the end. At this point, I think everyone's seen it. I'm pretty sure every channel that I'm subscribed to has played that video either yesterday or today. So we'll play it at the end. If you haven't seen it yet, it is good. But we're going to put that at the end. I think everyone has seen it so far. All right. So let's go. Let's get into it. I don't think I really need to say anything. So let's watch some chord. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Have you not opened the room?
I can literally do it from my pad, so I don't.
Well,
if you let me in the breakout room.
All right, I will.
I'll do that after this.
Oh, yeah, you can't be 2 places at once.
Yeah.
I have a hard time being 1 place at once. Jenny, would you come and get this one? I don't want to dump these all on you at 5 to 5. So Mr. Jelinek is done. The esteemed James McWheel is here. The alleged James McWheel is here. Good afternoon, sir. What's your name?
Ian Charles Tiffany.
Good afternoon, Mr. Tiffany. I'm Judge Middleton.
Hi, Judge.
Hi. Also present here is Deborah Davis from the Prosecuting Attorney's Office. Mr. Keith Stickley is here from the Public Defender's Office. Mr. Tiffany, you're from Angola. I don't know if we've met before. I think maybe we did in the past. You're charged with possession of a controlled substance, heroin, as a second or subsequent offender. That makes that an 8-year offense. You're also charged with carrying a concealed weapon, a pistol. That is a felony punishable by up to 5 years imprisonment. Count 3 is the felony firearm charge that nobody likes to hear about. That is a felony. It carries a mandatory minimum 2-year prison sentence, preceding and consecutive to any other sentence you might receive. You're also charged as a habitual offender. This is all alleged to have occurred in the city of Three Rivers yesterday, December 1st. So I did get a praxis on this. What I should have done is printed those out.
Your Honor, you're saying I was in control, I had heroin?
Well, let's take a look. That's what the complaint says.
No,
believe it
Your
was a
Honor,
mixture
there
of
was no
cocaine.
controlled substance whatsoever.
All right, well, hold on a minute. What the complaint says is heroin, signed by Joshua Robero. Let me take a look.
Not at all, Your Honor.
All right, let's take a
There
look.
was no controlled substance.
Okay.
And as far as this gun goes, I
Well,
Hey, hang on a
don't-
second, hang on a
yeah, don't-
second, sir.
Don't say anything
Yeah.
much at this point. We don't want to compromise your rights.
okay.
Well, I haven't seen this in a while. It was alleged to be a scale with white powder on it in Chorboy, which is more connected to cocaine, specifically crack cocaine than heroin. Then they found a Kel-Tec 9mm in the glove box with a round in the chamber, reported stolen from South Bend, Indiana. He said it was most likely crack cocaine residue on the scale. He uses cocaine heavily and has for the last number of years. The small amount of crack cocaine doesn't trouble me, but the gun does. Let me ask this, Mr. Tiffany, are you on probation or parole?
No, sir. No, sir, I haven't committed a crime. I'm a convicted felon from 30 years ago. Like I said, I just bought this car 6 days ago. I had no
All
idea
right,
this gun was.
All right,
All
okay.
right, hang on,
all right, hold
hang on,
on.
sir.
How did you end up in Three Rivers?
I was bringing a girlfriend of mine here. I gave her a ride and I made a wrong turn.
I guess. What do you do, sir? What's your occupation?
I'm disabled.
What kind of work did you used to do?
I used to be a machinist.
Are you on probation or parole
No, sir.
or bond?
No. None.
And you live in Angola, Indiana?
Well, I'm in between Angola and South Bend.
They're not close
trying to-
together. That must be an hour and a half drive.
An hour drive, yes. I'm trying to find housing.
Yeah, Debbie's sitting there. I told you guys that I want to try to put more Debbie Davis into my clips. She's not always in Judge Middleton's court. So when I see her, I try to find the best one I can. And this one was good. So we have Debbie Davis. Yeah, let's go. I don't know what else I was going to say. My mind was moving, but my mouth was just like, no, we're done. Just hit the play button.
All right. No criminal activity other than a wrong turn. You're not on probation or parole. There is a felony firearm count here, which would carry a mandatory minimum prison sentence. You are an out-of-state resident with prior felony convictions. So I'm going to appoint an attorney.
Okay.
You have the right to hire an attorney of your own choosing if you wish, but I want to make sure that you have one. I'm going to appoint an attorney in the public defender's office. I believe is going to assign Ross Truckee.
Okay. Yeah, I can't afford, I'm on disability, so I can't afford
All right,
anything
I'm gonna
really.
set a pre-exam conference for December 17th at 8:30. I'll be here. And if a preliminary examination is needed, it'll be December 23rd at 1 o'clock. I'll be here then too, I think. Anyway, because of the reasons I stated, gun in the car, one in the chamber, previous felony convictions, out-of-state resident, longtime drug addiction, I want a surety bond. I'm gonna set the bond at $2,500, cash or surety.
Your Honor, may I speak to this?
Yes, certainly. I usually don't have the prosecutor here. Ms. Davis wants to give input regarding bond.
Your Honor, according to the records that we received, he does have an active warrant out of Steuben County, Indiana, for drugs that was just from this summer. And he failed to appear a couple of times down there. So I would ask that it be set a bit higher. The sureties don't tend to go looking for people. He had recent domestic violence and intimidation charges. So
I've never had
Hang on, sir.
domestic
Sir, hang on.
violence.
Hang on a minute. Hang on a minute.
All right, well, apparently you have an open warrant out of Steuben County, Indiana, which is Angola. And the problem is if you bond out, they're gonna take you to Steuben County and then I may not get you back. So I'm gonna set the bond at $10,000 cash or surety. There's a pending warrant for you from another state. No drugs.
I don't know if there's a whole.
No firearms, no assaulty behavior. And again, if you are making the bond, I'm assigning you to pretrial release services. So you're probably gonna sit here.
Yes, sir.
Mr. Truckee will come see you. We'll get the police report. They'll get the laboratory reports back. The complaint alleges heroin. The affidavit would seem to say it's cocaine. And so we'll have to iron that out. Also get more information about the open warrant for your arrest from Steuben County. And is your girlfriend in Three Rivers?
No, sir. No, sir. That was just a girlfriend. I was giving a ride to Three Rivers. She's
Oh,
not
she
my
doesn't live-
girlfriend.
All right, but does she live in Three Rivers?
No.
All right,
I believe the location was a Spartan Motel.
okay. That's not a good place to be. All right, Mr. Tiffany, I will be seeing you on December 17th. If you post bond, you need to check in with the community corrections and the instructions are on there. If you don't post bond, I will see you on that date.
So my bond is
December
what?
10,000 cash or surety.
So that's.
So you can hire a bondsman.
Not 10%. Okay. Okay. Thank you, Your Honor.
All right, thank you. All right, now what we're going to
All right, that was a fun way to get started, right? Real quick, 2 questions. Colin, does the defense attorney insulting Judge Boyd have to answer to the local bar, chapter, or association? Potentially. I'll say potentially. I don't think it's automatic. I think someone would have to file a complaint. I would imagine that's how that worked. So they might. If Judge Boyd decides to go that route, she may not. I have no idea. No idea how it works. But yeah, I do. Yeah, I think my answer was sufficient. That's all I know about that, though. Well, isn't Debbie a big deal now? She is, but not till January 1st. That's when she starts. So she's still technically working under what's his name? Can't even remember his name now. Marvin, Mr. Marvin. So yeah, she's not technically in her role yet. She just works for the prosecutor's office right now, getting ready for him to leave. So she's still working. They're also very understaffed. So that's why when you hear Judge Middleton saying we weren't expecting someone from the prosecutor's office here today, or we're trying to get someone from the prosecutor's office here, it's there's 2 of them. There's only 2 of them, and 3 counting Mr. Marvin, but he's pretty much mailed it in. so far. I'm not going to comment on that. That was enough. So there's only 2 prosecutors in I think at least 3 courtrooms. There's more than that. I think there's 5 in the building, so I think there's 5 judges there. Yeah. All right. Anyways, let's move on. I think he's
Here,
just
right,
done.
Dawkins?
He's just done.
Damien was here, a docket call, right?
He fired Debbie and then hired her back because she won the election, and so I just think he's done. Yeah. Again, let's move on. I don't want to say anything that I'm not allowed to say.
Can you make an announcement, please, in the hallway? Oh, is his stuff still there? It's going to be Damien Johnson. Come on up.
Hey, Your Honor, is there a need for a Spanish
I'm
interpretation?
so sorry, Mr. Palm. Does anybody here need the Spanish interpreter? I don't think we do. Okay, Mr. Palm, I am so sorry. I apologize. I'm going to go
That's
ahead and
okay.
release you. You have a great evening.
You do the same. Thank you.
Yes, sir. All right, Mr. Dawkins, go ahead and get it started. What is the monthly rent?
There is no rent. These are squatters.
Okay. And so you're just asking for possession?
Yes.
Yes, sir. Mr. Johnson, what's going on?
I'm not a squatter, but I think I need to seek legal counsel.
Okay, well, that should have been done prior to, so.
I didn't get the.
Yeah, it absolutely would. If I shared personal information or details that I'm told off the record, yeah, absolutely, it would get my views up. But I would lose friends, and it's not worth it. But I know what you're saying. I get it.
Notice until last week from my daughter.
Okay, well, you got served on November the 8th.
I wasn't served. I didn't get a notice until
Who's
last
Jay
week.
Johnson?
That's my son.
Okay, well, your son had the paperwork the whole time. So
But
you can
he's
take that up with
suing me
your
as
son.
a squatter.
Huh?
I lived there. I was paroled there.
Okay,
I
so
don't understand how I'm a squatter.
can I talk?
Sure.
Okay. All right, Mr. Johnson. So I understand you think you're not a squatter. Prove to me that you're not. Do you have a lease?
No,
Okay. So how do you have rights to that house?
it's the family home. My
Okay.
mother passed away in the home, and
Okay.
the heir goes to.
Are y'all relation?
This is my mother's
Stepson.
It's your stepson? Okay, and you're the owner of the property?
Correct.
not the owner.
We're about to find out who the owner is. Okay, I'll be with them shortly. It looks like there's no, let's see. Mr. Dawkins, do you have proof that you're the owner?
Yeah, I think so.
Because right here it says the owner. Who's Johnny?
He's previous owner who died 3 years ago.
Okay, so I just needed to see what that it was conveyed to you because I'm not seeing nothing on that. Bear County. Okay.
I thought legal aid was prejudiced against square sponges, though. You didn't just make that up? Now my whole life is in ruin. I thought that was a thing. I thought it was a thing. Dude brought a will.
Mr. Johnson,
Dude brought a will to his court hearing. That's commitment. He wants you out, man. he brought the will.
So it looks like Johnny Herbert left a will. And he gave all rights to Christopher Dawkins and Joanna Dawkins.
And then
So they now own all his property.
my mother passed away. She has a will.
Okay.
And that's what I haven't seen. So he's saying that's my will for my grandfather, but mother's will,
Well,
that states that it goes to the children.
no, not necessarily, because he's still alive. So his part never died.
But her part does not go to her children.
Well, do you have that will?
That's what I'm saying. Nobody gets me the will since my mother passed away.
So how do you know that there's a will?
Because my sister says it was, my brother
Well,
said
if
it
I
was.
say there's a piece of gold over there and I can't find it, is it really there? I mean, I need proof. I can't just
And that's why I
go
said I
on.
just need legal counsel. I had got this a week ago to show up in court. I had to take off work to make sure that I don't, kind of get everything going, but I just need to speak with somebody. I had to try to go out to the legal counsel for minutes ago, and they said they can only represent the case they're here for. So I just need a 15 days, some kind of day notice to get it together, because I don't have proof, and nobody has given me proof of my mother's will, proving that her 4 siblings or her 4 children have access to the house.
So unfortunately, court was today and we've already tried the case. So you have every right to appeal it if you like. But at this point,
Oh, that wasn't me. That was somebody on Zoom. Absolutely not me, but it would make sense if we thought it was.
with this paperwork, he is entitled to the property. And as of right now, he doesn't want you there. So,
Yeah, could you imagine? This guy is the stepson of what did he say? He said it's my mother's stepson. So he's not calling him what did that make him? Your half brother, step brother, whatever it would make. Yeah, step brother. He didn't call him as my stepbrother. He's my mother's stepson. So your mother passed away and owned the house and the house went to him instead of you. Just saying, there's a lot of drama that we don't know about on this case. That's for sure.
Mr. Dawkins, are you willing to give him any time to move out or are you wanting possession?
Possession.
All right, I'm gonna make a copy of this as well, so keep in that folder. All right, Mr. Johnson, as of right now, judgment is in possession only. You do have 5 days to move out, or you can appeal it. If you need any paperwork on the appeal, you can go up to the front, okay? And then, Mr. Dawkins, if you want to swing around here to the right, my clerk's just gonna scan it in and she'll give you back your copy, okay?
Do you want the,
Dude dipped.
file in?
Did you see how fast that dude ran out of the court? He's like, all right, gone. I got 5 days to move. I got to get this stuff started. I'm sure that's not why it was running, but that was kind of hilarious.
The, my wife's will? Do you want that as well?
If you could put it in there. if you
Okay.
like. Yeah, just give her a minute. Just have a seat right there. She's
Okay.
gonna go make a copy.
All right. That was a quick one. I think the next one is it's a gun charge. and
Please?
it's- yeah. All right. I was just making sure. This judge has 2 personalities. I swear he has 2 personalities because he deals a lot with almost like a specialty type of sobriety court where his morning dockets are usually a bunch of probationers coming in and him congratulating them for doing well on probation. It's kind of how his morning dockets go. So when you see him, supportive and happy, it's strange to see him on a case like this where he's just like, nah, no, not doing it. All right, here we go.
Eric Sarmiento. All right, very good. And who is on behalf of Mr. Sarmiento?
Strasser on behalf of Mr. Sarmiento.
All right, Mr. Duffield.
John Duffield on behalf of the people of Michigan.
All right, very good. And what are we doing?
He's entering a guilty plea to attempted reckless use of a firearm.
All right, Mr. Sarmiento, you understand you have a right to proceed to trial, and if you went to trial, the prosecutor would be obligated to prove you guilty beyond reasonable doubt of all the charges against you.
Sir.
you understand further that if you make a plea here today to the lesser charge, you're still going to be, there's not going to be a trial of any kind. The people will dismiss the higher charge of reckless, and you'll be telling us you're guilty of attempted, and that's how the matter is going to be resolved. There will be no trial. Is that your understanding, and is that your intention?
Yep, I understand.
And has anyone tried to frighten you or force you into doing this?
No.
Has anyone made any promises to you that I'm not aware of?
No.
Are you a citizen of the United States?
Yes, sir.
Are you on probation or parole for any other criminal convictions?
No, nothing like that.
The allegations here indicate that this is an incident that occurred on or about December 7, 2020. Does that sound correct?
Yep, that's correct.
The allegation indicates that this incident occurred in Ganges Township of Allen County in the state of Michigan. Is that correct?
Yep, that is correct.
The allegation is you attempted to recklessly or heedlessly or wantonly or willfully use a handle or discharge a certain firearm, specifically a rifle, without due caution, circumspect to the rights or property of others. Is that true?
Yeah.
And what did you do in that attempt?
I was shooting the gun behind the shadow once.
I'm sorry?
Before acting my judgment choice.
You were shooting a gun where?
In the backyard of my cousin's house.
And what made it reckless or heedless or wanton?
Well, it was a residential area. We didn't know we were shooting bottles, but we didn't know it was around people. We had a warning, but I didn't really hear it that night until we got.
Wait, sir, you're telling me you're guilty. So you're telling me you're guilty. Were you shooting around people? Were you endangering people by shooting in this way?
No. I mean, no, we were shooting at the ground.
You were shooting at bottles, but behind the bottles, were there people or people's houses, or were people living there? I mean,
no.
Well, then what makes this reckless, wanton, dangerous? What made it dangerous, sir?
I'm pretty sure it made it reckless because people heard the gunshots around, so they were all together shooting.
No. I need you to tell me what made this reckless. You need to own it. You need to take responsibility.
Yeah, that's what I was saying, sir. We're shooting. We didn't.
All right, set the matter for trial.
Did you see the prosecutor right there? The prosecutor was not happy about that. I don't know what answer the judge is looking for. I really don't. He's asking what made this, firing the gun in your backyard reckless. I would assume maybe he's within a city limits or an area where you're not allowed to discharge firearms. That's what I'm going to assume. He should know that. If that's the case, he should know that, and the attorney should have told him. There needs to be something more to this, apparently. And you guys like, yeah, I fired a gun outside. Why was it reckless? Because I fired a gun outside and I wasn't allowed to? I don't know what the judge is looking for here. I really don't.
All right, you can leave the court, sir. We'll set the matter for trial.
I'm sorry?
We're setting the matter for trial.
Okay.
You can leave the court. You're all set.
Okay, thank you. Can I ask some questions?
I'll give you a call, Mr. Sarmiento, in a few minutes.
Yep. All right. What else?
Will I know what the next?
No, not you, Mr. No. You can call your attorney.
Yeah, not you, man.
All right. Ms.
Why did that just make me laugh so much? He's like, what else? And the guy's like, oh, I don't know. What else do you want to talk about? Why? Why did that just make me giggle? I don't know. Sparkle Poots, all the twat waffles are present. That is awesome. You know what? If I can find this quickly, I don't remember where I put this. Ah, it is here. You know what, twat waffles? It's been a while. Let's do it. All the twat waffles haven't been present in a bit, so let's go. Twat waffles. All right. For all of you that were confused right there, the Twat Waffles had a theme song. That was their theme song. Yeah, that's awesome. Welcome. That's awesome. And Kimberly, thank you so much for the $5 super chat. I appreciate it. I feel like I need to play another theme song just for you. But Kimberly, thank you so much. I appreciate it. All right, next case. Let's move on. What do we got next? I've started falling in love with this court just because there's always drama. And this is just a great legal battle. That's what this is. The defense attorney, I can't tell if she's mad or if she's just very passionate. You guys let me know.
Calling case 2400658, People versus Terrell Cox. We're here for a calendar conference. Appearances, please.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724, standing in for the attorney of record, APA Sona Movsisian.
Good morning.
And good morning, Your Honor. May it please the court, Leanna Belcher, P80177 on behalf of Mr. Cox. Sir, will you please state your name?
Terrell Cortez Cox.
Good morning, Mr. Cox and Ms. Belcher.
Good morning, Judge.
We're here for calendar conference. Any motions that are filed by January 21st, 2025 will be heard at at final conference on January 28th, 2025. And that date will be the last date by when a settlement will be accepted by the court and any timely motions entertained. And Ms. Moore, I don't know if you are aware of whether there is an outstanding offer, a pending offer now.
Judge, I have had contact from the APA who's actually handling this case. There is no offer at this time. She indicated she will have one to defense counsel shortly and well before the final conference date.
Okay. Okay, it looks like our transcript for the preliminary examination is due on January 2nd, 2025. Ms. Belcher, do you anticipate filing a motion in this case?
Your Honor, it depends. There are a few discovery issues that I would like to place on the record today. It may necessitate the need for the defense filing a motion.
Let's hear.
First and foremost, Your Honor, the examination was held, as Your Honor has pointed out, the transcript is due. It came out at the preliminary examination that the complaining witness in this case provided text messages between herself and my client to the police. Those were brought up through direct by the prosecutor. Upon cross-examination, the complaining witness admitted that prior to turning over those text messages to the policing agency, that she deleted some of those messages and could not recall information on the deleted text messages. The defense has requested, since the complaining witness has her cellular device, that that phone be obtained by the officer in charge and that an extraction be done on the phone, as I've consulted with an expert on cell phones, and a lot of times deleted text messages can be recovered through that extraction process. My understanding, and I don't want to speak for the people, but they are not willing to get the complainant's cell phone, which I find to be problematic. Given that they are the ones that are introducing these text messages and wanting to use them, I believe it's only fair to the defense that I have the full and accurate log of the messages between the complaining witness and my client. They have requested that I go find my client's cell phone. As the court can see, my client is in custody. And I believe the simplest solution so that we do not have to delay the trial in this matter is to obtain a phone that the complaining witness has in her possession and extract the messages. Further, she at the exam testified that she texted her child's father the morning of the alleged incident and immediately disclosed. So there are other relevant messages that she has sent out on her cell phone that the defense wants. And the second thing, Your Honor, that I requested was that the complaining witness testified at the examination that she used social media platforms maintained by Meta to communicate with my client. My understanding with Meta is that a search warrant affidavit has to be provided to Meta for those records to be turned over. I've made that request shortly after the exam to the people. The officer in charge, I believe, was preparing the documents, but I do not know the status of the request for those Meta records.
I know that's
All right. Yeah, she comes in hot. And this is like I said, this is a good attorney battle. So she is saying, hey, we just had this preliminary exam and it was bound over to circuit court. So now we're in front of you. The complaining witness testified about texts that weren't in discovery. And the prosecution is using these texts as questions to, while they were questioning the complaining witness. So we want to see these text messages, and the prosecution's about to respond, but yeah, why they don't have the text? That's a really good question.
mouthful, Ms. Moore. Do you know anything about any of that?
Judge, I know a limited amount about those matters, and defense counsel and I did just have a brief conversation prior to stepping up for the case to be called. So first of all, this is actually not addressed by defense counsel, but I do just want to make sure that I stated it. We are still waiting on lab reports to come back. As soon as our office receives those, we will turn those over to defense counsel. I'm going to address the Meta records first. I am aware of the fact that the Instagram records were requested by APA Movsisian to the officer in charge a while back, and that APA Movsisian followed up with that to make sure that we are getting those records. My understanding is that those have been subpoenaed and should be available. The information that I have is defense is requesting them going back 5 years. I'm not sure the scope of those records or whether or not all of those records are still a part of the company, but anything that is obtained from the company will be turned directly over to defense counsel. Turning to the larger issue of the victim's cell phone, I first want to state that the people and the police department are not in possession of the victim's cell phone. The victim turned over text messages to the police. An entire extraction was not done. And we do not actually have possession of either the phone or a full extraction for that. I understand defense's position, but even if we had the victim's phone and did an extraction, it does not guarantee that the messages will be there. There is a chance that deleted messages can be recovered, but it is not a guarantee. The officer in charge in this case is looking into other means and paths of obtaining this evidence, potentially going through something other than a phone extraction to see if there is a way to get those deleted messages and make them available. But frankly, and this is APA Movsisian's position, if defense wants to get into the phone and wants that extraction, defense has the opportunity to file the appropriate motion, get it signed by the judge, and have that happen that way. I would also like to emphasize the fact, and defense counsel did address this, but I do think it's important, that the text messages that are actually, I think, at issue, the deleted messages the defense is talking about, were messages between the victim and the defendant, which does mean the defense and the defendant have their own copy of those messages and would be able to produce those without needing to go into the victim's phone.
Your Honor, may I respond?
One moment, please. The alternative means that you mentioned, Ms. Moore, what is that?
I apologize, Judge, I'm working with information from another APA. So I only have the information that the officer in charge, that's Officer Parrish, Parish, with the Detroit Police Department, is looking into those other means. I don't have the details about that. And if the court, I would also ask that if the court is going to demand that the people, or is considering demanding that the people get a phone extraction from the victim and turn that over, I do ask for one more court hearing where the APA, who is actually more involved in the case, knows the details, and potentially even the officer in charge can appear to address that issue prior to the final conference date.
And Your Honor, the defense's concern is that, as the court's aware, we are being rushed to trial. I have a defendant who is in custody. He does not have his phone. And the idea that the people will get to cherry pick and utilize messages that they've introduced themselves, that they know are not accurate and complete records, is ludicrous. This would be my oral motion for those records, Judge, so that we do not delay Mr. Cox's right to a speedy trial because the people just do not want to call their complaining witness and have a phone extraction done. The idea that they potentially could not be recovered, is that what we're going to operate off of? The idea that maybe they're not there without actually trying to do a forensic extraction? And I have the same question, Judge. What other means? Is this going to be an issue where the defense has provided records on the eve of trial? I don't understand why we need to delay the process. If we're being rushed to be put on a trial track and rushed to go to trial, and the people have the opportunity to make one phone call to the complaining witness who's being cooperative, who showed at the exam, who indicated she still has her cell phone, why not just do an extraction on the phone?
So my question to you, Ms. Belcher, is you made two references to being rushed to trial. We don't have a trial date scheduled in this matter yet, do we?
No, Judge, we don't. And that's just from information that I've received from other courtrooms where they've indicated that they are getting pressure from higher ups to go back to a 90-day trial track, which is quite challenging from a defense perspective, as I'm sure the court can appreciate. It's hard to juggle multiple clients, multiple trial dates, and pressure to get these trials scheduled as soon as possible. I also have to balance the concern of Mr. Cox being in custody and not wanting somebody to spend unnecessary time in custody.
All right, this is what I'm going to do. And I do appreciate your coming, Ms. Moore, but I agree that before I make a decision, it would be, in all fairness, appropriate for me to have the assigned APA here. I will accept an oral motion though, because I do believe that requiring the defense to file one would be an unnecessary delay. And so, Ms. Moore, do you have counsel's Movisian? I'm going to get this. So the V is silent?
No, it is not. So it's Mauve and then C, like SEECN.
Movesian. Okay. Well, Ms. Belcher.
Yes, Your Honor.
How long will you be available today?
Your Honor, I have to leave this premises by 11:30. I have to be in Monroe for a CSE exam.
What about this afternoon on Zoom?
I have an in-person jail visit scheduled with Monroe. They typically do not allow us in person, so I've had to go through a chain of command to get permissions. So that would be challenging to reschedule, Judge. And I do know Ms. Movesian is in trial.
That is correct, Judge. She's in a trial that is extending well past the time it was supposed to. Otherwise, she would have been here in person, and I apologize for that.
No, I understand these things are dynamic. It's difficult. The best we can do is estimate how long matters are going to take. Okay, what about, do you know what day of trial this is for her?
Yes, it is day 7 of trial. I anticipate it will last at least, I would argue, the next 2 days, but she should be available starting on Friday.
Okay, let's resume on Friday, and we'll just give Ms. Movesian.
You get an A for effort, Judge.
Yeah, I appreciate the court's interest in trying to learn it.
I think names are important. And getting them right to the extent that we can is awesome. Okay, so let's come back then on Friday. What time will Attorney Movsesian be available.
I anticipate either first thing in the morning or later in the morning from what I can see. What about Ms. Felcher?
Your Honor, I do have a matter scheduled before you at 9 a.m. that day. I do have an examination at 10:15 in 36th District Court. I can always do this matter at 9, or I can come back after the exam.
This one, let's. Oh, we have a lot of things scheduled in that 9 o'clock block. Let's do it after your exam. About what time do you think you'll be done? You know what? Let's do this. Let's do it at 9, and I'll make a note to handle this first. If you're here first, we'll get right to it.
I will be here first.
Okay.
I will let APA Movsesian know.
Okay. So we'll see everybody at 9 on Friday. We'll see you then, Mr. Cox.
Thank you, Your Honor.
Thank you. I appreciate the court's patience and defense patience.
Thank you, of course.
See you Friday.
Yeah, that one was fun. For those of you that have followed me for a while, I love a good attorney battle, and that one was good. As I don't remember who said it, someone said it. Instead of the normal dumb, we actually get to see attorneys doing a good job on both sides, and yeah, both sides made sense. I feel like the defense had a fair argument if they're gonna bring in text messages that they don't have access to into evidence while complaining victims on the stand. I think there's a lot of issues with that. I really do. All right, I've got a lot of membership milestones to go through real quick. Before that, Linda, thank you so much for becoming a new member. I appreciate it. Welcome to the family. That is awesome. Welcome, Linda. Thank you. Lexa, good to see you, Lexa. 10 months, 2 months before a year. Thank you so much, Lexa. I appreciate it. Always good to see you. Again, Allie T for 7 months. Thank you so much, Allie T. Jedi rolling in at 11 months, 1 month before a year. Thank you so much, Jedi. Kimberly coming in at 5. Kimberly, that is awesome. Thank you. And Terrapin at 2 months. Terrapin, thank you so much. I appreciate it, bud. And then I had a question. Oh, yeah, Francis. There are definitely tactics. There's strategy and tactics both ways. Depending on what kind of case you're running, what the charges are, sometimes it's good to try to go fast. From a defense standpoint, we want to get this done fast because we don't think the state's going to be able to get their case together in the amount of time. We're guaranteed this time under the speedy trial rule. We can, let's try to force them to trial. But then there are times where you want to just push it out. There might be 2 or 3 complaining witnesses that, that if you give them 3 or 4 months, they're going to just, stop caring about the case. You're not going to be as passionate about it. So there's definitely strategies on both sides, and you just got to be able to read the room to figure out what's best for you. But hopefully you never have to go to trial, so you never have to, decide whether or not you want a slow or a fast trial. But I understand your point, though. All right, let's move on. Did I catch up? I think I did. I don't think I missed anybody. Okay, just making sure. Okay, let's move on. Let's see. What do we got next?
Thank you. We are adjourned.
I had to put a funny one in. This one's funny for all the wrong reasons, but I laughed at this. This is good. This one's good. All right, let's go.
Mr. Stennett. What? Did somebody say something? Who are you?
Gerald Stimmer. Jerome Stimmer.
I'm almost there. I'm with Mr. Stennett. What happened to you, Mr. Stennett?
Fell out of a tree.
You fell out of a tree?
Yeah, building a fort for the kids.
Mr. Stennett!
I cracked 7 ribs, choked collarbone, punctured a lung. On the 26th of last month, they took out disc 3 and 5.
Mr. Stennett, Mr. Stennett, Mr. Stennett. I don't think you should be climbing a tree anymore.
No, the tree's coming down.
I think that's a good idea. Thank you, you too.
She wasn't saying, I don't think you should be climbing a tree anymore, because, she was worried about the tree. I don't know how old he is. I'm going to guess he's in his 70s. That's my guess. Yeah, why are you climbing a tree? That's not even the funny part of this case.
All right. And Mr. Stennett, I'm not going to lie, and I'm not on the record yet, but I'm not going to lie. I'm sick of seeing you.
No.
I'm sick of seeing you.
I'm sick of coming here.
Please stop. Stop.
24 CT 103.
Yes. I see you. You're like, I see you more than I see my mom and dad.
I know it's not funny.
And I don't know what to do, quite honestly, because you need to get your license and you need to pay those back fines and fees to Minnesota or wherever it is. Because I'm going to tell you, really, not joking, I see you more than I see my family.
I know.
And I don't know what else to do other than continue to fine you, or send you to jail. But if I send you to jail, what's that going to serve? Because you're not going to be paying your fines or getting your license, right?
Yep.
We will go on the record in the matter 24 CT 103 24 TR 923 and 924. State of Wisconsin versus Vincent Stennett. The state appears through District Attorney James Renicky in person. Mr. Stennett appears in person without counsel. We're set here today in this matter for.
All right, we need to. There's rolling on the floor laughing. Yeah, I get it, but we need to do falling out the tree laughing. We need to figure that one out. Whatever the acronym for that is, that's what we need for this guy. Falling out the tree laughing.
An initial appearance, not guilty pleas for the tickets. I think I can guess an offer on this. But first I'm going to say you were served a copy of the criminal complaint, correct?
No.
You're quite extremely familiar about the charge and the maximum penalties, correct?
Yep.
I don't have to go over them because you've been here like every other day, right?
Yep.
So you understand them, you waive reading, not guilty pleas will be entered on your behalf. You're entitled to a jury trial. I'm just going to take a wild guess here, Ms. Renke. Wild guess that it's plead to the charge for cost.
Correct.
Because, Mr. Stennett, you've been here over and over and over again, and you're not able to get your license because you have so many fines and fees. But the more this happens, Mr. Stennett, the longer it's going to take you to get your license and the more fines and fees you're going to have. Stop driving. Stop driving. Okay? You got to stop driving. What's it going to take for you to stop driving? Apparently a fall out of a tree, maybe.
Yeah, that helped.
Maybe you didn't fall hard enough.
Oh, I fell hard enough.
Not to stop driving, please. Stop driving, Mr. Stennett. Stop driving. Because I'm telling you, I may have to throw you in jail. I may have to throw you in jail for not driving with a valid driver's license.
I would suggest possibly having a signature bond, and that way, if it keeps happening, we can do some bail jumping charges.
That's could happen. That probably sounds like not a bad idea, because to have it hanging over your head so you stop driving. Because here's the thing. This is what I'm going to do. I'm going to have a $200 signature bond. Condition is find out how many fines and fees you have and where you have to pay them and what you have to do to get your driver's license back. And you're going to tell me at the next court date. All right?
Okay.
Exactly how much, all of those things and what you have to do.
Yeah.
Because you need to get your license back. And if we need to figure out a plan and what you need to do to get that back, other than number one rule and number one in the plan is what?
Not driving.
Yes, not to drive. Stop driving. All right. I am going to schedule you for January 31st at 11:30. January 31st at 11:30. I will see you then. We are adjourned.
You'll need to sign his new bond.
Yep, you'll need to come up here and sign a bond. Gerald Stimick. Yes, are you Gerald?
I'm Jerome Stimick.
Oh, you're Jerome. It says Gerald.
It says Gerald on it.
Yeah, it helps when I unmute. I told you that one was funny for the wrong reasons, maybe some of the right reasons. The judge was nice to him in the way that she could. If let's just say this, if that person up there on this, the defendant was, let's say, 25 and had as many driving while without a license, there would have been major repercussions for that. This guy's like 70. He's been driving for longer than all of us have been. Well, longer than the judge been alive, longer than I've been alive. She's like, just stop. Stop climbing trees. Stop driving. Heineken. Good to see you, buddy. Good to see you. Thank you for becoming a member. I feel like you have been a member in the past, but thank you so much for re-becoming a member. Anyways, good to see you, my friend. Hopefully, I'm sure that you've recovered by now. But just checking on you. How's your shoulder doing? Okay, we're moving on. We got one more before the judge board case. I think this is the last one, and then I have to upload a different video for the judge board because, like I said at the beginning, completely forgot to add it to the video because I'm an idiot sometimes. All right, let's go.
826 SC AAC Credit Union versus Rusty Jackson. We're here in small claims. What that means is we're trying to get this done without any attorneys. Parties are not represented. We're also trying to get this done without anything like a jury trial request, but for this to be decided right here in front of me. And so if we are going to proceed, I need to ask a question or two first. Christine, what is it you do for AAC Credit Union?
I'm the collection manager.
All right. So even though I cannot see you, I'd ask for you to raise your right hand the same way Mr. Jackson's going to raise his right hand so I can swear you both in. Do you swear or affirm that any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
Yes.
Yes, sir.
All right. Mr. Jackson, this may go quicker if I...
Yeah, we used to call him Judge Biggin until he shaved his beard. I think he saw our channel and was like, you know what? Biggin's a super sweet guy, and I don't want to be in his shadow, so I'm going to shave my beard. But he used to have this sweet beard, and yeah, we called him Judge Biggin. Can't do that anymore. Now my beard is longer than his.
I just start with you. Do you believe that there is, in fact, money you owe the credit union, and this is more about how and when you're able to pay them, or are you here contesting that you owe them money?
I am going to be contesting it on the grounds that this was brought to court once before, and I showed up, and they did not.
Okay. That wouldn't be a grounds for contesting that you owe them money. That case probably got dismissed.
That would be grounds for dismissal.
But they can.
I love it when a judge just looks someone dead in the eyes and just like, okay. Like, no, that didn't make any sense. Okay. Sorry, I had to pause. I was laughing too hard.
Just refile it. It's not like a criminal case where there's double jeopardy.
No, but I'm pushing. I want to push for dismissal on grounds of without prejudice because I showed up and they didn't. If it would have been the opposite way around, the fault would have been on me, and I would automatically would have owed them the money. It would have been deemed that in their favor.
When are you saying that this affidavit, in other words, this case was...
All right. So what he's saying is this collection company filed a lawsuit. He showed up to court and they didn't. He's saying if I didn't show up, there'd be a default against me and they would automatically win. There would be a default against you, but there are things you can do to set aside a default. You have things you can do when you don't show up to court. They have things they can do when they don't show up to court, like refile the charges, not charges, refile the lawsuit. That's what's going on here. Just because you don't understand it doesn't mean you're right.
Filed This is a new case, sir.
No, it is not, sir.
No, I'm saying this case, literally. This was, this may have existed before and been dismissed if the plaintiff didn't show up. But what I'm saying is I have no history on this case, so this is a new filing.
Right, but I understand that you do not have the paperwork or whatever in front of you, or that it's been not been provided.
Mr. Jackson, they cannot show up 10 times in a row and it'll get dismissed 10 times in a row. Then they can just file it an 11th time. So you are dealing with a new case right now. There would be no defense to say it should be dismissed because they didn't show up last time. That's not a legal defense to being sued. The legal defense to being sued would be you don't owe them money because your car was not repossessed and there wasn't an amount still owed on it. So that's fine. We'll have that hearing. I just don't want you thinking that because they didn't show up one time, they can't sue you. That's not a thing. All right. So we will start with you, Christine. Why are you asking for $3,473.53?
Yep, this is on a repossessed vehicle back in 2020, and that amount is the leftover, the deficiency balance that's still owing after the vehicle was sold.
All right, so the vehicle was sold at auction and you deducted whatever amount was recovered from the amount still owed.
Correct.
And this is the leftover balance.
That's correct.
All right, so Mr. Jackson, why would you not owe that?
I guess I can't give you a reason.
Okay.
Because if this would have went through the first time that we were here and this went to court, if I would have had ample options to be able to pay it. But as it sits right now, I'm now in 2024, I'm single parent of 2. I'm going in the process of a divorce. I'm having a hard time with being able to find ample work in the availability that I have. I have.
Okay, but sir, you're not arguing that you shouldn't have to pay this money back. You're arguing, you're explaining why it's going to be problematic for you to pay it back.
Well, it's
right?
going to be problematic. But if this would have been taken care of, if there was no reason that they shouldn't have been able to be here. It was a Zoom meeting. We didn't go into court because that was COVID. So all they had to do was the same as right now, which is pick up a phone and be there. And I would have paid the money.
And you think the penalty for not being there should be that they can't get their money? They're barred from
things that I'm not a lawyer, sir. I'm not, but by things that I've read is that dismissal without prejudice means that they cannot come back after me for it.
No, sir, it's the exact opposite. Dismissal with prejudice means they can't refile. Without prejudice means they could refile as many times as they want until they get it done.
I'm sorry, I'm using the wrong terminology. Like I said, I'm not a lawyer. I never studied for any of this, whatnot.
And just to let you know, not showing up may get the case canceled, and it sounds like it did, but that wouldn't be a dismissal with prejudice. That would always be a dismissal without prejudice, meaning they could refile. Because you never know what the reason is. It could have been that they were never served, or they got in a car wreck and went to the hospital. Whatever the reason was, that's why it would always be without prejudice. And they would have to properly refile and properly serve you again. But that's why we're here today. They did both those things. So you're kind of in the position you were back then. And
so
they didn't show up in the past wouldn't really have much of an effect on the case. You would still owe them the money because the car is still repossessed and there was still an amount due.
Right. Right.
Okay. So I would find then for the plaintiff here in the amount the damages request $3,473.53. The only other thing I'd need to explain to you, sir, is the credit union had to pay certain monies to get here today. They had to pay a filing fee to court, and they had to pay to have you served. That was $104.04. They are also able to recover that as costs. So that's why your dollar amount will be slightly higher. Looks like $3,577.53. So we will type that judgment up and send it out to parties. Just a reminder to parties, the court does not do collections. We do expect that the parties would be in contact with each other to satisfy that judgment. But I will tell you, Mr. Jackson, I'm sure that the credit union is used to people saying, well, I can't pay that all at once right now, and work out some sort of
I can't even pay $5.
But we're all set for what we need to do here today, other than I need to explain to you your rights on appeal. You do have a right, since we had a contested hearing, to say, I don't agree with what just happened there. I want to appeal this to general civil in front of the district court judges. But to do that, you must do two things. One is you must ask for that within 7 days of today's date. And two, you must ask for that in writing. You cannot just request it orally. You understand your rights on appeal?
Yes, sir.
All right. Then I'm going to go ahead and release parties. We're all set here.
All right. You know what the worst part about this case was? This guy walked into this hearing thinking I got this in the bag. I'm going to ask for a dismissal without prejudice. And I got this one because they didn't show up. And he learned real quick that is not how it works in collection cases, small claims. That is not how that works. All right. That is the end of this video. So, as promised, I will share the Judge Boyd clip for those of you that haven't seen it. This was the clip I tried to share last night and promised I would. Let's see. All right. I don't think there's much I need to say to introduce you to this clip besides this is Judge Boyd. She is in Texas. She loves her flowers, her handbags, and her mother. Let's go.
Right here, Your Honor.
All right, I'm going to ask you the same question that I asked everybody else. Has an acknowledgement of discovery been done?
Yes, you're gonna get audio. Hopefully, you can hear it. Also, Judge's mic is really low for the first, I'm gonna say, minute or two, and then she turns it on. So you're hearing her through the mic on the podium right now. I feel like she may have muted her mic. She figures it out in about a minute or two and turns it on. But she is really low at the beginning. But that's not my fault. That's Judge Boyd's fault.
I have signed a few of them at this point.
All right. So has there been any new discovery?
Were they supposed to show up this morning? I don't know. Judge Boyd deleted her docket this morning really quickly, and I didn't get to see any of it this morning. So I have no idea if they were supposed to come back this morning. So for those of you that don't know, this happened yesterday. So this was yesterday. I think this was yesterday in the afternoon. Yeah, it was. It was her PM docket. Judge Boyd did go live this morning, but she's always one of the last dockets I go through because she doesn't delete. And she deleted her docket this morning. So I don't know. Maybe they did show up and it was chaotic and she just deleted it real quick. I don't know. But if that was the case, a lot of other people would have put the video out. I haven't seen any videos of them from today. Yeah, I haven't. Okay. Yeah, I haven't seen anything from them today. I don't think I've seen any Judge Boyd from today. So if you guys have seen anything, let me know.
Not to my knowledge.
All right. So you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court's file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket. Okay. There are a couple of cases that are ahead of you, so those cases may end up going before yours. We'll just see where we are. Okay.
That's correct. Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm going to have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right. Be here exactly at 9:30. Okay.
Okay, yes.
All right. I'm supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice in one
And
of those
say that,
courts.
and it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your
All
Honor,
right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what? I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm going to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing.
Oh, see, and that's what I had a problem with. And look at that smug look on his face. No. And I will tell you this. I have talked to a lot of judges since I've started my channel. And the first question I always ask them is the YouTube question. How do you feel about YouTube? They all just about say the exact same thing. It is what it is. You know, there are some judges really like it. Like, I really like the transparency. I really like that it's out there, but you know, it's just in the background. It does, you know, it is what it is. Some judges have said, you know, I like that it's transparent, but I could care less about it. You know, it's just nobody has said, oh, I am doing this strictly for the clicks and views. The fact that she keeps getting this brought up against her is ridiculous. Her chat's not even on. Calm down, defense attorney. So when I hear a defense attorney bring up YouTube, I just get mad. I get mad because they don't know what they're talking about. They have no idea what they're talking about. Oh, man. All right. We're going to finish this one up. Saffron, thank you so much for your super chat. I'll read it here in a second. There's only like 2 or 3 minutes left of this left. So we're going to play it up, and then I'll read the 2 super chats that came in. But man, oh, man, the YouTube thing. Stop.
You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right. Thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bear County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are older
I'm
than
asking
yours.
for a record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
Rulings
ends
are
up
being made,
happening.
there should be a record, right?
Excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. There's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. And then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I
be
have
here.
other cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true,
You
because all of
understand?
those courts got
All right,
prisoners
good
for
luck to
conflict.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today.
Thank you,
Right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
things
here's your
can actually
reset.
occur.
Sir,
And they're courts of exactly the same
Sir.
jurisdiction.
right this way, sir.
I love the little shoulder hop Judge Boyd just did right there. You know, I really wish we could have started a trend after this hearing yesterday, because this is, I think, the 4th or 5th time I've seen this clip now, and that attorney thought it was appropriate to interrupt the judge because they weren't on the record. Why? It's never appropriate to interrupt anybody. But he said, "Why can't I interrupt you? We aren't on the record." He put himself above her. I would have twisted that around and said, "Sexist attorney thinks that he's better than the judge." I would have labeled him, with whatever term, whatever masculinity term, throwing that out there. Like, oh, because you're not on the record, you think it's okay to interrupt somebody? Is it because she's a woman? You're going to twist things around, because that's what you're doing right now. You're twisting things. You're throwing YouTube interface. It doesn't make any sense. So I'm going to twist it around right back on you. Let's see how you handle that. Because she's a woman and you're a man, you felt that you were allowed to interrupt her because she wasn't on the record. Good job, you. Now you're an asshole. Again, there's a reason why I don't generally say how I feel during my videos, because I have a very strong opinion about a lot of things, and when I go off cusp, I generally get pretty angry. So yeah. Anyways, that's it, guys. We ended with that. We're gonna end with that. Yeah, no, that's why I said, like, I'm gonna twist it around because he just twisted it around, is what I'm saying. I'm not saying he is, but if he's gonna use Judge Boyd not being on the record and twist that for ammo against her, I'll twist it around too. I mean, we can do that. I can take one portion of what he said and make him look like a jerk. I mean, he made himself look like a jerk, but that's the thing about, when you're reporting on things, you can just take snippets and create, what you want your viewers to see. We all could have done that on this guy. Let's move on. Well, there's nothing to move on to. That's it. That's it. I'm gonna pop this back up because my outro is about to play. I got some super chats to read, and then we gotta find someone to raid. Beldy. Maybe she didn't want to give the YouTube airtime. Maybe. Yeah. No. Absolutely. I have no idea. I know she had a docket this morning because it popped up. I got the notification for it, and then it vanished like an hour later. So but that's absolutely possible that she didn't want the airtime. She knows. Judge Boyd knows she's all over YouTube, so she knew that clip was going to be everywhere, and it has been. It's been on every channel. Every court channel I'm subscribed to has played that clip. Saffron, this is a man that wonders what the inside of a coffin looks like. All right. Thank you, Saffron. I appreciate it. Sparkle agreed. He the YouTube hog, dick. Thank you, Sparkle. Mayor, good to see you, buddy. Haven't seen you in a little bit. Good to see you. Thank you so much for the 5 gifted memberships. I do appreciate it. Welcome to the 5 new members. Mayor, that is awesome. Thank you so much, my friend. I appreciate it. Thank you all. Thank you all for hanging out with me tonight. I do appreciate it. It's been a great night. It's been a fun night. And yeah, I got to play that clip that apparently upset me more than it did yesterday. I don't remember being that mad yesterday. I thought it was hilarious. But no, apparently I was mad about it. Yeah, it was the YouTube comment. I don't like it. I don't like it when lawyers essentially throw YouTubers under the bus, because that's what that was. You're doing it for the YouTube views. Like, stop it. All right. We are going to be rating Lone Wolf like usual. I only see him on. He's generally the only person on. It's either him or KCC, and KCC goes live a little bit later. I feel like this was a long stream tonight. I don't see KCC. Hold on. Let's see. Is she even on the upcoming list? She's not even on the upcoming list. What's going on with KCC? Anyway, we're going to hang out with Lone Wolf. Thank you guys so much for hanging out with me tonight. Thank you all so much for the super chats, the gifted memberships, the membership milestones. You guys are awesome. Thank you for being good sports with my ridiculous opinions on things. Yeah, it's a weird night, apparently. You guys are awesome. Go tell Lone Wolf. What message do we want to tell Lone Wolf today? We got to change it up. Always telling him that I'm better than him isn't that's getting old. We got to change it up. What should we say tonight? Go tell him. What can we think of real quick? I can't think of anything. I could think of some personal things that would be funny, but I don't think that would be funny to everybody else. All right, you know what? We'll keep it the same tonight. Go tell him that I'm a better YouTuber than him, and I'll think of something to change it up tomorrow. So you guys have a great night. Go tell him I said hello, and I will see you guys tomorrow. Until next time, bye.
Thank you.